Hello, my name is Michael Tesoro, and I prepared this video case note on the decision of Justice Murphy of the Federal Court in relation to ACCC v Samsung Electronics, which was a penalty judgment that was handed down fairly recently. Bit of background about myself: I'm a competition and consumer lawyer, and I've been running my own practice, Tesoro Legal Consulting, for the last 14 years. I help companies with competition and consumer law matters. Prior to that, I worked at the ACCC for 15 years in a variety of different roles, one of which was as a Director of Enforcement. Now, the outline of the presentation, I'll start with a bit of an introduction, then discuss the decision of Justice Murphy, then spend a bit of time looking at how he assessed the appropriateness of the penalty, which was agreed of $14 million, and then finish with some commentary. Now, the ACCC commenced legal proceedings against Samsung back on 4 July 2019, so quite a long time ago. And as you can see in the media release there, the ACCC alleged that Samsung had falsely and misleadingly represented that the Galaxy phones were suitable for use in and could be exposed to all types of water, including ocean water and swimming pool water. And that was not true. They also said that Samsung did not have a reasonable basis for making a number of representations. It hadn't tested the phones to know how the water would affect them. Also, there was this contradictory representation on the website saying that the phones should not be used in the beach or the pool areas, so it's not advised for beach or pool use, and also denial of warranty claims. And then the ACCC also alleged there that the phones were not suitable for the use which had been promoted to consumers. Now, in the ACCC media release, they included some of the representations, and they were pretty clear representations about the ability to use these phones underwater. You've got a fellow sitting underwater checking his phone out. You've got another picture here of somebody surfing, and that wording there says that do everything you love this summer on the Galaxy A5, whether it's listening to your favorite song by the pool or capturing your Sunday surf session at the beach. So they're pretty clear representations that you can use these phones in the pool and at the beach. Here's another one. This is my favorite, the fellow lying on the air mattress with the phone there, and he could basically take it easy and relax because there wouldn't be any risk to his phone. Now, the ACCC alleged that these various representations constituted breaches of Section 18, 29, 1A, 1G and 33 of the Australian Consumer Law. They're sections which are often put together in many ACCC cases. They effectively deal with the same thing, the uses and benefits of the particular product. Now, before getting into the substance of it, it's important to realise that Samsung had done some testing of their phones and had discovered from the testing that they were water resistant, that water could impact the phone without getting inside it. But the problem was the water would collect in the charging port and could corrode that, particularly harsh chemicals from the pool and the salt water from the beach. So what they did was give a warning message to consumers that if water was or moisture was detected in the charging port, warn the consumer not to charge the phone because it could short out. And even though they'd done this testing, this sort of meant that they were aware that the product would be impacted if pool or seawater got into the charging port and the consumer sought to charge the phone. And you can see there the admission that there was a material prospect that the charging port might be damaged due to corrosion. Samsung also admitted that if the charging port corroded significantly due to the moisture that collected in it, there was a material prospect of the phone not being able to be used anymore in the future. So Samsung, after a lengthy period of contesting the case, admitted the allegations made by the ACCC, which were somewhat narrowed during the course of the litigation. And as you can see there, the admissions were made that the 9 advertisements which were the subject of the litigation represented to consumers that certain Galaxy phones, and it's quite a large number of different models, were suitable to be submerged in pool or seawater, when in fact there was a material prospect that the charging port in those phones would be damaged due to corrosion. And those representations that they made were admitted to contravene all of the sections alleged by the ACCC, so section 18, 29, 1A, 1G, and 33. Now, some background information is important. The number of phones sold over the relevant period was 3 million phones, so that's a very large number of phones. And I think the judge concluded that the representations about the benefits of this phone would have been a large factor in encouraging consumers to buy this particular phone. Financial position is also quite important of Samsung Australia. As you can see there, it's got very large sales of over $2 billion each year from 16 to 21, but quite low profits. As you can see, there's a loss in the first couple of years, and then in the final year, 2021, a profit of $43 million. And the conduct more or less happened between 16 and 18. After that, the conduct had ceased. Now, the penalty analysis is set out by the judge, and he refers to section 224 of the ACL, which says that there's 3 factors which have to be considered: the nature and extent of the act of omission and any loss or damage suffered as a result of that. Secondly, the circumstances in which the act of omission took place, and thirdly, whether the person has been previously found to have engaged in any breach of the relevant part of the legislation. Now, the penalty analysis goes on, and Justice Murphy says that other matters relevant to the exercise of the power to impose a pecuniary penalty are commonly referred to as discretionary factors, but then he says they're not truly discretionary. So effectively, these issues should be considered in every penalty decision that's being considered under the Australian consumer law. So you can see there the size of the contravening company, the deliberateness of the contraventions, whether senior management were involved, the corporate culture conducive to compliance, whether there was a disposition to cooperate with the authorities, in this case the ACCC, whether the company had engaged in similar conduct in the past, financial position of the contravener, and whether the conduct was systematic, deliberate, or covert. So they're all the factors that Justice Murphy sets out as ones that he must consider in coming to a conclusion as to whether the agreed penalty is appropriate. Now, the penalty analysis starts with working out what the correct measure is. And as you can see, that there were so many breaches, because every time a representation was seen by a consumer, it was a breach. So it falls back on this idea that because there's just so many contraventions, and if you were to magnify them all out, it would become unworkable. So as he says there, the theoretical maximum remains relevant to the extent that it reveals what the legislature thought about the contraventions and how serious they were, but it's so large, it actually becomes unnecessary and unhelpful if in fact it was possible to work out. So that's sort of saying that, well, we're not going to go through and do a massive multiplication exercise because it's just simply too many breaches, and we'll arrive at a number that's sort of so astronomical that it doesn't make any sense. Again, I'm not too sure I understand this analysis, because it does seem to turn on how many courses of conduct there are. And it seems that judges talk about this issue before determining the course of conduct. And if there are a limited number of courses of conduct, then the penalty analysis isn't actually that difficult to do. Anyway, I'll come to that in a few minutes. Now, as you can see, most of the conduct occurred before the changes to the penalty regime. So we're talking about the the $1.1 million regime, which applied prior to September 2018, at which time it changed to $10 million, 10% of turnover, or three times the benefit derived from the conduct. So Murphy has decided to use the old regime in calculating this penalty. Now, the first issue, as I said before, is the courses of conduct. How many courses of conduct were there? And it was quite surprising. The ACCC actually contended that there was one or two courses of conduct. It proposed a single course of conduct because all the advertisements were making the same broad message, which seems very strange because that would be saying that the penalty for one course of conduct should be $14 million, which would be quite a strange number given the old penalty regime had a maximum penalty of 1.1 million. However, the judge did not accept that analysis. He actually said that he thought there was more than one or two courses of conduct. He thought that it was appropriate to look at the different types of media being used by Samsung, where they'd advertised, and as a result of that, he concluded that it was actually 4 courses of conduct. He provided this table in his judgment where he put the text content on the website distributed by email as the first course of conduct, the video content as the second course of conduct, posts on social media as the third, and then print content, basically brochures and booklets that were sent out. So he thought there were 4 courses of conduct. Then he went to consider the various factors, and the first was the nature, extent, and duration of the contravention. And again, the ACCC submissions here didn't seem to be very fearsome. They were fairly muted, and he concluded that it was quite a serious contravention. There was conduct over a long period of time, affected a great many consumers, and it constituted a serious contravention of the Act. And accordingly, the conduct merited the imposition of a substantial pecuniary penalty. Then the circumstances of the conduct were considered, and here he noted that Samsung had actually implemented a testing regime to try and work out how resistant the phones were to water, and they had genuinely sought to design a phone that would not be damaged by water getting into it and the phones being exposed to water. So they were trying to do the right thing. They effectively failed to do the right thing. And then he said there's no evidence to suggest that Samsung was aware of the risk that the phones wouldn't perform as represented, and there was no suggestion they took a chance marketing the Galaxy phones with a known or suspected defect in order to increase its market share. Now, I think many people could take issue with that conclusion, but again, the evidence wasn't before the judge, so that seems to me to be an appropriate submission or appropriate conclusion to reach. Loss of damage caused. This is another issue where the ACCC and Samsung basically said it was impossible to work out what loss or damage was caused to consumers. Again, the judge was happy to infer that many of the consumers who'd purchased these phones would have used it in the manner suggested in the advertisements, and they are entitled to assume that a large company like Samsung would not advertise that the phones were able to be used in water if that was not the case. So I think the conclusion that Justice Murphy reached was that there had been loss or damage because people would have been encouraged to use their new Galaxies in the pool and in the surf. Then he looked at Samsung's, and this is a Samsung Australia size and power, and as I said earlier, they had a turnover of 2.9 billion in 2021. In the relevant period, I think you'd probably say about $2.6 billion. And then he concludes that a penalty of 14 million exceeds Samsung Australia's profit in the period. So he looks at the profit they made over the 6-year period, and there was a couple of years with quite significant losses, so it netted out to a particular amount. And then he concludes that the penalty of 14 million is actually 14.5% of Samsung Australia's total profit over the last 6 years. So I guess he's trying to work out a number that may achieve some specific deterrence, and a penalty that's 14.5% of your total net profit over a 6-year period sounds like a significant number. Then he looked at the cooperation which Samsung had provided to the ACCC. And again, it was somewhat surprising that ACCC are arguing that Samsung should be given significant credit for cooperating with ACCC. And again, the judge didn't agree with the ACCC. He concludes that they did not cooperate greatly with the ACCC, and so they should not receive much credit. He said they were quite late in making admissions. There was trenchant opposition to the ACCC's case for many years, and let's face it, the case started in 2019 and was settled in 2022, so the case went for 3 years. And it was obvious that the ACCC were going to win this case, and that's the only time that Samsung agreed to cooperate. So it's a bit strange here why the ACCC would look at a company that has been fighting a case for 3 years, litigation that had 23 listings over that 3-year period, number of administrative and case management hearings. ACCC had filed a lot of its evidence already. Why the ACCC would say that Samsung deserves any credit for cooperation is a bit puzzling, and clearly the judge didn't accept those submissions from the ACCC or Samsung. Then the conclusion reached by Justice Murphy was that the penalty of 14 million was going to carry a sufficient sting or burden that would deter Samsung from repeating the conduct in the future, so it would achieve specific deterrence. Also, it should serve as a salutary reminder to other large providers of smartphones to avoid such conduct. So he believed that $40 million would also achieve general deterrence. And as you can see, it's sort of creating this imperative on these companies to be able to ensure they thoroughly assess and validate all claims they make about their phones and other electronic equipment. And so he believes that it is sufficiently large, this penalty, to achieve specific general deterrence. And again, he refers to the fact the penalty constitutes a significant proportion of the total profit, net profit, that Samsung has made over the last 6 years. Now, it was a bit strange that earlier on Justice Murphy identified a number of factors which have to be considered in a penalty judgment, and then he didn't seem to address them. First one, previous contraventions. That's clearly a relevant consideration both under the legislation and under the case law, and there's no discussion of it. I'm assuming there were no submissions made to the ACCC by the parties about this. Samsung doesn't have the worst record under the Australian consumer law. There was a previous case in 2013, which would have been under previous legislation, where they gave an undertaking for misrepresenting the energy savings, the bubble washing machine. So there was a previous case there, but it's a factor that should have been taken into consideration in the penalty judgment. Also, there was no consideration of how the breach arose and the role of senior management in the breach occurring. So that's a significant issue that needs to be addressed in a penalty judgment. Again, I'm assuming there was no submissions made, so I guess the judge is in this unenviable position of not being able to analyse a factor where there's no evidence before him. The other factor that wasn't looked at all was the culture of compliance within the business, whether they had an effective compliance program and whether they ensured that it was up to date and that staff were being trained. So that's the third omission from the penalty judgment. And again, no criticism of Justice Murphy. It seems to me that if submissions aren't made by the parties on these factors, the judge has no way of being able to ascertain what the relevant considerations are in relation to all these factors. Now, just looking at the final penalty, if you look at $14 million for 4 courses of conduct, that means it's $3.5 million per course of conduct, and that's under the old penalty regime of $1.1 million. So that's a fairly sizable penalty. And so I think the amount is, as the legislature has determined at that time, that $1.1 million was the maximum penalty, that a penalty of this nature is appropriate, and the judge was well within his discretion to accept it. I guess when one considers it in terms of Samsung's total sales, it is a very small penalty, but again, that wasn't the penalty regime which applied to the vast bulk of his conduct. But just taking that into consideration for a moment, if you look at the turnover of $2.6 billion, 14 million, it represents 0.48% of their turnover. So that doesn't quite sound quite as likely to achieve specific deterrence. But one thing I think about the profits that should be noted is that, is Samsung effectively taking a lot of its profits overseas instead of Australia? So as you can see, I didn't have any more current figures, but 2016 is the year where some of this conduct occurred. And that particular year, Samsung Australia paid various subsidiaries overseas $1.95 billion for the purchase of electronic equipment. And the tax rate in Korea is a lot lower, the corporate tax rate, than it is in Australia. But I think it's well known that Samsung and a number of companies use these offshore distribution companies set up in low tax jurisdictions to take the profits from the sale of the electronic equipment. So I don't know whether the judge's focus on the profits generated by Samsung in Australia really saw the whole picture here. There probably is some transfer pricing going on, there's some profit shifting, and the amount that is reflected in the financial statements may not tell the whole story. So just for commentary, I think the penalty sounds about right, given that it was under the old penalty regime, and is a large penalty under that regime. And I guess, as I said before, on the basis that the legislature set penalties at a level which it believes will achieve specific general deterrence, it seems to tick that box. It was surprising that after setting out the relevant factors which should be considered in a penalty judgment, that Justice Murphy didn't consider them all, but that could be due to the fact that he wasn't provided with submissions and evidence on those factors, so can't make it up. It is disappointing, however, that the ACCC is not making submissions to the court on the previous compliance record of the company, the involvement of senior management, and also the culture of compliance. And furthermore, the ACCC submissions on some of the factors seem particularly lenient, like to argue that Samsung should be given credit for cooperation after fighting the case for 3 years in a fairly aggressive manner seems strange to me. And also arguing it was a single course of conduct, didn't quite understand that submission either. So I think the ACCC, I don't know why it was putting its position in such a lenient way, but I guess ultimately it didn't matter because the judge formed his own views on a number of the key factors, and I think probably you would say he came to the right decision. So that's all I had. If you have any questions about the presentation, feel free to drop me a line or send me an email. Bye-bye.